President of Sri Lanka and appointed as the President's Council. Welcome, sir.
Good evening, ladies and gentlemen. Mr. Santana Krishnan, as I always say, the father of the lawyers' cricket, Learned President's Council, distinguished invitees, and my fellow cricketers. It is nothing but a great privilege and honor to be a part of the lawyers' cricket and a part of the Sri Lanka Lawyers Cricket Club for its inception. And it gives me a great deal of pleasure to be here and to be here with my colleagues from different jurisdictions and who have taken a lot of interest and trouble to come over here, to travel down to Colombo, Sri Lanka, and to play and to be a part of the 8th edition of the Lawyers Cricket World Cup. As I had a little discussion with Dr. Malika Gunasekara, I think last evening, he indicated that the whole idea of this conference, though as the master of ceremony indicated that you are having a busy schedule, perhaps that may be the reasons as to why the participation is perhaps may not be up to the expected numbers. But this conference is very important, where we as members of the legal fraternity, one community from different jurisdictions, will discuss certain topics which are very common to all of us in our day-to-day practice. A few minutes ago, when I touched the mind of the godfather of lawyers cricket, Mr. Santana Krishnan, in fact, he himself being a mediator and an arbitrator in international, several jurisdictions. He's a gentleman who travels all around the world within few days. The alternate dispute resolutions are something, perhaps we may not be able to ignore it in the years to come. If you look at the Sri Lankan context and the Sri Lankan jurisdictions, and we have, I think, our President's Council in his presentation, perhaps he will touch upon, we are in the process of introducing a different act or a statute related to arbitration. And the mediation, we are not merely concentrating on the community mediations, but now we are mainly concentrating on commercial mediations and the negotiations. And those are, and the arbitrations, of course, is one of the most, the promising and a popular alternate dispute resolution mechanisms that is accepted all around the world. So, whilst playing cricket, you as practitioners from different jurisdictions, taking time off and getting back to the atmosphere of courts and to discuss and to share your knowledge, impart your knowledge which you have gathered and acquired whilst being in the legal profession with your colleagues from other jurisdictions, perhaps might be one of the best things that one could expect whilst getting involved and engaged in a sport. At the opening ceremony, I remember saying that when it comes to cricket, it's not merely a game for Sri Lankans. It is our way of life. It is our way of life, as everyone expects. These games must play with its two spirits, something which is we find lacking or diminishing rapidly. So therefore, there is a great deal of responsibilities rest on our shoulders as practitioners and members of the legal community to not only to advise and to foster and advocate in all our respective jurisdictions that people, the administrators, stakeholders, to follow what they ought to follow and to comply the provisions of the law. So I perhaps may not take much of a time because there is, when I looked at the names of the panelists, we have very eminent panelists who will discuss these matters, the topics that they have chosen and to make the presentations. I think all of you are eagerly waiting. First, I must tender my apology as well for getting late due to some personal and professional commitment, which took a little time than expected. So I wish each and every one of you good luck, and all the panelists as well, so that we can certainly acquire some knowledge which could be useful for us to take it back and then to put it to practice when we just back in our black tie and a black coat when we are in our jurisdiction. So thank you very much for extending an invitation. Once again, Dr. Gunasekara. Actually, he is my batchmate. Back in 1993, I think over 31 years of friendship, which always we always cherish and value. And I played under him when he was captaining the Sri Lanka Law College cricket team, and that is the history that we share in common as the one little community and being batchmates. So on behalf of the Bar Association of Sri Lanka, Management Committee and the Executive Committee and the entire members of the Bar Association of Sri Lanka, I extend my gratitude to all colleagues of different jurisdictions who have taken trouble to come over and travel down to Sri Lanka and to be a part of the 8th editions of Lawyers Cricket. As you all know, that Sri Lanka has gone through some difficult times, troublesome times, and we are trying hard to get out of it. And this is not the best of times in terms of politics and especially the economy is concerned. So, but amidst that, our local counterparts has taken a lot of trouble in organizing. I do not know whether you all have had any difficulties. Hopefully, it would not have happened in that way. So they have done their best to make your visit comfortable and to give the best possible, at times which you can cherish when you leave this country. So hopefully you all would have had. Wish to extend my gratitude to Mr. Santana Krishna, his team, and all the managers and the seniors who have come from different jurisdictions with the players for participating the 8th edition of the Lawyers Cricket World Cup. Thank you very much for your invitation, and it was nothing but a great pleasure and honor to be here and to speak few words.
We will now witness the official unveiling of the conference. Conference Chair Dr. Dan Malika Gunasekara, Attorney at Law and former captain of the Sri Lankan Lawyers cricket team to the 2011 World Cup, Barbados, West Indies. Dr. Gunasekara is a practitioner in civil and commercial law with a specialization in maritime law, having well over 25 years of
cricket club in Colombo, which is a very old cricket club, and we had the opening ceremony at the Tamil Union Cricket Club, which is called the Colombo Oval. And also the other distinguished panelists and speakers, we are yet to see the attendance of one speaker, Mr. Hirandi Alvis. He will join us as soon. As well as a few of the panelists who are going to participate at the panel discussion today. Now, when selecting the topics, I wanted to concentrate more on the let's play clean idea that to address certain issues that may arise in the sports when it comes to sports disputes and the doping issues and so forth. So with that idea in mind, we also thought that it is better to get a more concrete with the laws and regulations when it comes to sports and also for arbitration, as the prevailing arbitration act dates back to 1980s, and now we are going to have a new legislation for arbitration, and mediation will also follow in the time to come. So with that, all that in mind, we thought of having this conference or rather to address the very pertinent issues arising in sports arena. Talking about the history of this sports conference, organized in conjunction with the Lawyers Cricket, I remember when I played the first World Cup for Sri Lanka in 2007 in Hyderabad in India. We had the first sports conference there, and it was a sheer success, and we had been talking about various topics and issues arising in the sports arena. Then in 2009, we went to Cambridge. I was the vice captain of Sri Lanka Lawyers Cricket team. And even there, in Cambridge, in the Cambridge University, we organized a very important sports conference, and we were very much privileged and proud to have a Sri Lankan King's Council, or rather Queen's Council, to address as the keynote speaker back in Cambridge at that time. And then when I captained Sri Lanka Lawyers Cricket team to Barbados World Cup in 2011, where Sri Lanka came to finals, it was also a very interesting thing that the sports conference gave much of the education and knowledge to the cricket playing sportsmen all around the world who participate in different World Cups. Thereafter played in Brisbane, in New Zealand, in India, Sri Lanka in 2016, and back again in 2023 in Sri Lanka. But to add a point that this World Cup was not hosted by Sri Lanka. It was hosted by, it is hosted by India. Sri Lanka is facilitating and giving all the hospitalities in order to go ahead with a very good back with a panel discussion. And in the panel discussion, we are mainly focusing on setting a hub based in Sri Lanka, in Colombo. And we know already that Sri Lanka's modern city of the future is the port city, as we call, or the Colombo. It is also called the Colombo International Financial City. And that will be the future of Sri Lanka. And we may be able to get a facility in the port city to accommodate sports arbitration and mediation dispute resolution as an ADR system, so that all the countries can come there and resolve their disputes. So in the panel discussion, they will more focus on the country-wise issues, especially Sri Lanka, India, Bangladesh, and in the Q&A session, we will open up for the audience to raise questions and get everything cleared. So we are expecting more crowd to come in with the proceedings of today's conference, as we know already 2 matches are taking place. So that means 4 teams are already engaged in the tournament. Unfortunately, it was not meant for that. As you all know, that due to the bad weather conditions, we had to have all the participants as well as all the teams and their players will pose for an official photograph in the lawn of these premises, followed by the evening's party organized by Sri Lanka Lawyers Cricket. So with that, I come to the end of my introduction to the conference. And thank you very much for listening. Thank you very much, Sadia, for that nice introduction. And I welcome you all again.
Ramamurthy Santanakrishnan, an advocate of the Supreme Court of India, founder of the Lawyers Cricket World Cup, and Honorable Life President of the Commonwealth Lawyers Association. Mr. Santanakrishnan, a pioneer in organizing the Lawyers Cricket World Cup since
Thanks, Sadia. Let's play clean. That's the motto of the in terms of what's happened here, so many years, we discussed anti-doping. We discussed betting and many similar situations where rules have come to be interpreted. We spoke about the rules as to how the sports law as such should be. And finally, when we reached here, thanks to Dan and all his colleagues, he thought of a motto called "Let's Play Clean." And what we thought for the first time is, all the while we have been talking so many things in and around the sports law, for the first time we are making an attempt to think in terms of, do we, as we are all practicing law, ask the courts to find who is right and who is wrong? Is there any alternative way of thinking? So that's the basic thought which made us to think in terms of ADR. Do we think in terms of deciding as to who is right and who is wrong as it happens in the court? Or alternatively, is there any other method by which we can resolve the disputes? To share light on this, we have our keynote speaker, Mr. Jawad, who specially flew for this occasion. He has not come here to play cricket, but he has come here to share his thoughts as to how and in what manner we can look differently as far as the dispute resolution is concerned. When I was discussing with him, he was asking me a question, how all this happens. We meet biannually here. In India, we meet annually. If it is around 150 to 200 participants here, in India, every year we have 300 participants. By and large, whether it is World Cup or the local All India tournament, by and large, it is peaceful. By and large, we don't have any big major issues. Then he has asked me, don't you think this exercise by itself can be called mediation? I said the answer is yes. Although we might not have mastered the art, the science of mediation, which Jawad will definitely share with us, but all of us collectively have developed some kind of art. That art makes us, all of us together, spend 1 week, 10 days together, enjoy our company with each other, and the art is to mediate and whatever little misgivings are there, to settle and enjoy the game. So, to share more about this, we will not only hear from Jawad, and we have number of discussants who are going to discuss, and the initiative taken is by Mr. Nair, Ashwath Nair, who has not only framed the concept note, but the important issue that is going to be discussed is why we have to think of towards resolving the disputes, go to Switzerland. Why not we think in terms of having or creating an alternative forum in the Asia-Pacific region? So this is the thought which will be discussed at the discussion in the last part of the session, post-tea. So with these few words, I thank once again Dan and all his friends for giving me this opportunity and to carry off all of us together, not only to play cricket, but also to discuss issues concerning sports law. Thank you very much.
Thank you, sir, for that thought-provoking dialogue and analogy. We will now hear insights on the topic of overcoming irregularities in sports, accidental affair with a prohibited substance. Does intention really matter? From Mr. Dinal Phillips, President's Counsel, who has more than 40 years of experience in legal practice of commercial litigation, with a specialization in commercial arbitration and intellectual property rights. He has successfully appeared for several Sri Lankan cricketers before the International Cricket Council, currently is a sitting member of the International Chamber of Commerce's Court of Arbitration, and was a one-time member of the Sports Appeals Committee of the Ministry of Sports.
Good afternoon, everybody. Thank you very much for inviting me to be on this panel, though I must say I'm here more as a 12th man, trying to hold my end up till stumps are drawn. Because it was only the other day in my house, when we had a panel discussion, my good friend Dan requested me to fill in a breach. So that's why I say I'm a 12th man here. But I must say, before I proceed any further, please give a big round of applause to Dan, who single-handedly spearheaded this whole thing. I heard it mention a team, but I don't see any team with Dan. I don't know if, and I did give him a hard time right through, but that's me, Dan. But you're a great man. As far as this topic is concerned, let's play clean. What a wonderful subject. Probably better for the politicians, isn't it? I hope I'm not taken away somewhere. But anyway, this might sound a bit like a history lesson, but it's important to follow this bit. In 1882, the great English poet, Sir Henry Newbolt, wrote an interesting poem which ended up, play up, and play the game. But then, Sir Henry never expected what was to happen later in the field of cricket. Shortly after he wrote that poem, there was the W.G. Grace incident. A big burly man, Dr. Grace, went out to bat, struck LBW first ball of the match itself. Umpire gave him out. He walked up to the umpire and said, "This crowd is here to watch me bat, not to see you, umpire." And he carried on batting. Let's play clean. Then, later on in years, there was a gentleman called Don Bradman who scored runs willy-nilly. And the Englishman devised a scheme to stop him scoring runs and got the fast bowlers at that time to bowl more at his head and bowl at every Aussie batsman on the head and called the leg theory. Let's play clean. Then in 1973, I believe, England were touring India. And then there was the Vaseline scandal, where one of the English fast bowlers, to make the ball seam around on those wickets, put some Vaseline on his hair and dubbed the ball with it. Then we had an Australian, they are famous for this, bowled an underarm delivery to win a match. And it cost a few row and nearly had both countries declaring, nearly broke diplomatic ties. Years later, I had the opportunity to meet that bowler's brother over a beer, and I asked him about it. I said, it was not cricket. He said, mate, can you tell me what the rule was that prohibited him from bowling underarm? So I left it at that. Then there was the other player who was found, who took a diuretic, and he said his mom gave it to him, and who had a toffee in his pocket to get the ball to reverse swing. So all this is done in a sport which is called a gentleman's game. You see? So these all related to various incidents that took place in the field of cricket, which is called a gentleman's game. Let me get to the next slide. Get to the next slide. Right. There is a chemist somewhere hiding behind. You'll all know that. Sports is a religion. Let's be very honest about it. We all love it. I sometimes postpone my consultations if there's an interesting match going on. It's a way of money making for the businessmen, the franchise cricket, the sponsors. It's a holiday for others to go out and watch sport. Anti-doping regime. What then is the standard of proof? In a criminal action, it's beyond reasonable doubt. But in the early days, it is the athlete who has to show, and still is, that how he took all necessary precautions to avoid it. No point saying my mom gave it to me or my brother gave it to me. He had to show how the prohibited substance got into the body. So the burden of proof is on him. The violation occurs whether or not the athlete intentionally or unintentionally used a prohibited substance or was negligent or otherwise at fault. Now, interesting thing happened involving a Sri Lankan athlete, Shakila Das. How this happened, Lord knows. But whilst the sample A tested positive, sample B tested negative. And so she was exonerated. But the more important case, interesting case took place in the next case I given to you, which I appeared in. It was a Sri Lankan athlete again. Kalinga Kumarge, 400 meters recently, he won gold medal at the Asian Games. Test was done, and the bad news came to him that he had tested positive. I had a doctor whom I used to consult in such matters, Dr. Danath, and I took the adverse analytical finding to him, who looked at it and said, this is nonsense, this is 0.02 nanograms. It's so small that there is no way that can improve his performance. Unfortunately for us, despite making representations to the local WADA parties, they took the view that, well, 0.2 is 0.2. There is a trace of it. Sorry, champ. Sorry, Dina, we can't help you. Providence intervened, and WADA actually banned that laboratory in India. That laboratory is banned. And so without going into the exigencies of whether de minimis situation existed, and we had proof to show how careful we were in taking any items of food, any tablets, everything was properly administered. The tribunal then rejected the charges on the basis that the source was unreliable. However, with so much pressure being brought on WADA by international lobbying, that you can't put the blame on the accused, because general view is you're innocent until and unless you're proven guilty. WADA then softened its stance a little and decided that if the athlete could show no fault or negligence on his part, or no significant fault or negligence on his part, that will be an exception. No fault or negligence, there is no problem about it. Because if his drink was spiked by a third party, whatever it is, you can't blame the guy. But it could be that he took all precautions. But nevertheless, the drink got spiked. Now, the question is, what is meant by significant? I've not dealt with it there, but in a case involving the Rugby Football Union versus Johnston, and this Johnston should not be confused with Michael Johnston, the World Cup rugby winning captain of England. This is Ashley Johnson, where his wife, perhaps one of these very figure-conscious people, had fat-thinning tablets, fat-dissolving tablets. And had his own supplements, also tablets, were also there side by side. And he mixed the two. And the court, though brought the sanctions down, said having those side by side is an accident waiting to happen. So without a long sanction period, you sanction for a very limited period of 6 months. And they described, for the first time, significant was defined, which says, the adjective significant was to be interpreted purposefully and by avoiding the more restrictive de minimis restrictive angle. So it has to be understood what is meant by significant. How much trouble did they take? Now, there is a case I've given later, Powell versus the Jamaican Sports Association. This guy is a sprinter. He showed the tribunal that he took all precautions. His food was prepared from home, brought it, carefully monitored and eaten. All his medication was carefully monitored, but there was a prohibited substance in it. What did happen was, being a Jamaican, as you all know, they love to party. And at a party, somebody had put some prohibitive substance. So an 18-month sanction was brought down considerably to about 3 or 4 months. So you see what I mean by significant fault. So it's the very, very strict way of looking at things narrowed it down considerably. You see, I have said there in my note, according to the Court of Arbitration in Sports, to reduce the penalty of ineligibility, the athletes must establish 2 factors: the source of the substance on a balance of probability, and that there was no intention to enhance his sport performance by the substance. Johnston's case, on the balance of probability, he has been taking it for years. Here was his wife's tablets, here are my tablets. Powell said, my food was carefully prepared, medication properly done, etc., etc., etc. And he had no intention of doing that. So that's what it was. And he has to show how it entered his body. I will skip through a couple of other cases and go into a case of a gentleman who's currently very well known in Sri Lanka. The current chairman of selectors, Upul Taranga. In 2011, we got thumped by India in the World Cup finals. Upul was the opening batsman. And on a random check, they found that he had a very high degree of prohibited substance in it. I took it and got it examined. And the doctor examining held his head. He said, good God, what on earth has he been doing? What transpired was that Upul, I'm referring to him first time, I know him pretty well, had a shoulder pain in his left shoulder. And he's a left-hander and his throwing arm, there was a constant pain. So he went to the team doctor. And the team doctor prescribed something which he took. Now this is what you all must remember as sports people who are dealing with. There is repeated educational programs conducted for players or athletes on prohibited substances. They are given a little card to take with them wherever they go. They are entitled to question the doctor giving it and show him, saying, look, these are all prohibited substances. Please don't give this to me. Upul had the card. But he did not question the doctor. I had to file an affidavit in the case. It was black as hell. I put down the truth. Yes. As soon as the charges came, I said he immediately imposed a self-ban. I said, he's a poor guy from a very humble background, supports the entire family. And the doctor was the President of the Republic's personal physician, who was the team doctor for the Sri Lankan team. And he trusted the doctor and took it. British justice was at its best. He was giving evidence. He was asked whether he had any card that had prohibited substance. He produced the card as well. He carried it all the time in his hip pocket. Never mind, he brought it at 59 minutes or 11th hour in his pocket on good advice. But they were questioning him. Why didn't you question the doctor? Immediately, the presiding judge said, surely you do not expect a fisherman's son to question the personal physician of his president. He would have been awe of the man. I kicked my junior under the table. I knew the battle was won. You see, he had no intention of deceiving. He had a very clean record up to now. He goes to the team doctor, what can this poor guy do? He's on tour. And he got an ineligible period of 3 months, where he probably missed 2 weeks of a tour. And they were warm-up games, so he really didn't much. He was back there. But this is a classic case of no intention, prohibited substance plus, plus, plus. But it entered his system through no fault of his own at all. Then the other question is, which I said, was the qualitative test. How much of this quantity should be there? You remember the definition in Michael Johnson's case? Other than the de minimis? There's a Mariano Pureta's case, but I think for all of you all seated here from the subcontinent, the KJP case or the Kusal Janit Perera's case is more interesting. There again, which I appeared. KJP at that time was on a roll. And suddenly, the bomb fell. Adverse analytical finding. I personally went to Doha, to the lab, checked the second sample. They tested it. We were there till evening and said, sorry, that's also positive. We grilled him for 3 hours or 4 hours. He denied it. He said, well, if I have to face the consequences, I'll face it. Then I went to my savior, the famous doctor. Again, he looked at the adverse analytical finding and he said, this is, again, just mere 2 nanograms. Then as you said earlier, also the same thing. Why is that? Then he said, sometimes when you are an athlete performing at the very highest level, sometimes your body regenerates some of these substances. Because you're taking high protein into your system. I'm not a doctor, etc., but that's what I was told. And that then turns into energy-giving substance. I went to the ICC. They were not too pleased with this situation. And I thought, all right, you guys want to be funny. I got over to English solicitor who wrote a letter. He had done a couple of tests. He did a this truth test, put him under the cosh and checked him out, and did another thing we called a comb test. All those tests, he sent it and he said, this cannot enhance his performance. What are you talking about? ICC waved the white flag. And KJP played cricket again. And he's still playing. So, I think I've taken you all through the perhaps interesting bits of this thing of how to have defenses available when you're caught with this kind of substance. Ideally, no fault at all or no significant fault at all. And you must show how the substance got into it. And you have to be very, very careful. There are no friends here in this game. They're all out to pull you down. As we from the subcontinent knows, the best mango tree sometimes gets the most amount of stones. So, thank you very much for listening to me. Good luck.
Thank you, sir, for those detailed insights. It is a true pleasure to introduce our next speaker, Mr. A.J. Jawad. advocate, senior mediator, and arbitrator from Chennai to deliver the keynote address on the topic of mediation in the context of resolving sports disputes. Mr. Jawad has over 35 years of practice in the Madras High Court in civil and commercial litigation, as well as in constitutional law. He has over 15 years of extensive experience in the field of mediation, specializing in civil, commercial, and matrimonial disputes. He is a distinguished professional with a proven track record of conducting recognized national and international mediation training programs and coaching winning teams for prestigious international mediation competitions. Please join me in welcoming him to the stage.
Thank you, Sadhya. I came with a prepared speech because one, I didn't want to exceed my time. And number two, the topic is so important that I didn't want to, miss out on anything. So, respected conference chair, Mr. Dan Malika, President's Council, Mr. Kaushalya, who will be joining us again now. My good friend, Santana Krishnan, I don't see him. Where is he? Oh, yeah, there he is. The godfather of the Lawyers Cricket Cup, Mr. Hirendi Alves, and the panelists, Mr. Ashwath Nair, Mr. Dinal Phillips, Mr. Panduka Kirtinanda, Mr. Sayan Mukherjee, Mr. Mudassir Hussain. So, there is going to be a panel discussion by them on making Sri Lanka the best seat of sports arbitration and mediation in the Asia-Pacific region. So, ladies and gentlemen, I see some students also here and fellow sports enthusiasts. First of all, I'm very grateful to the organizers for giving me this opportunity, and it is a real honor to address you today. Now, human beings are drawn to sports activities since times immemorial. From the initial days of human civilization till date, sports have evolved from a source of entertainment to a global industry encompassing more than 3% of the world trade. It is one of the main revenue-generating industries of the world, and with the propagation of the internet and other forms of media, the sports industry is growing at a faster tempo. So an industry of billions of dollars with an all-encompassing worldwide presence is bound to raise its own disputes. This has resulted in the growth and development of sports law as a distinct jurisprudence in its own right. Sports disputes nowadays are not restricted to purely sporting issues such as selection, eligibility, and disciplinary issues such as doping, which was a very, very informative session by Mr. Dinal Philip, drawing on his own personal experience. They also include commercial disputes pertaining to promotion, marketing, corporate sponsorship, merchandising, and agency contracts. Now, the magnitude of the issues involved and the nuances make it clear that sports law will no longer be an applied law or an amalgamation of laws under some jurisdiction, but a distinct law in its own right. The Court of Arbitration for Sport, CAS as it is called, was established in 1984 in Switzerland to deal with all sports disputes. CAS, being situated in Switzerland, primarily gives advantage to the arbitrators, mediators, and advocates of Western countries, as visa becomes a major issue when it comes to this part of the world, from our part of the world. Since almost all sports disputes are time sensitive, the need to be at CAS at the 11th hour is what pushes the advocates, arbitrators, and mediators of our part of the world out of the league. So therefore, there is a felt need that there should be a similar sports dispute resolution body for the Asia-Pacific region, having its own rules, especially keeping in mind the cultural imperatives of our regions and catering to the needs of this part of the world.
The scope and modalities for establishing such a council will be discussed by the eminent panelists here. Suffice it to say that the primary objective of such a council would be to provide a specialized and impartial mechanism for the resolution of disputes within the sporting community in the Asia-Pacific region. By offering a transparent, efficient, and legally robust framework for addressing conflicts, the council would serve to safeguard the integrity of sport, protect the rights of athletes, uphold the principles of fair competition, and promote the rule of law within the sporting realm. It is in this context that I would like to speak on the importance of offering mediation as one of the services by the proposed council for resolving sports disputes. In recent years, the role of mediation in resolving sports disputes has garnered increased recognition and significance. Now, significantly, the ICAS, that is the International Council of Arbitration for Sport, which is the supreme organ of CAS, has introduced mediation procedures in May 1999 itself for the resolution of sports disputes. Now, Osman Kane, the former senior counsel to CAS, in whose tenure the mediation service was introduced, has said, and I quote him, "The International Council of Arbitration for Sport took the initiative to introduce mediation alongside arbitration." Now, this is very significant, what he says. As the mediation rules encourage and protect fair play and the spirit of understanding, they are made to measure for sport. Now, mediation as a form of alternate dispute resolution offers a very flexible, non-adversarial, and constructive approach to addressing conflicts in the sports domain. Now, by bringing parties together in a neutral and collaborative setting, mediation allows for open dialogue, the exploration of creative solutions, and the preservation of relationships, now, all of which are very integral to the sustainability and positive evolution of sports at every level. The scope of mediation in sports disputes is broad and multifaceted, encompassing a wide range of issues such as contract disagreements, selection disputes, commercial conflicts, interpersonal disagreements among athletes, teams, coaches, administrators, and governing bodies. Now, leaving aside disciplinary matters and doping allegations, which may require adjudication, as Mr. Donald Phillips had pointed out. Now, in each of the other contexts, mediation presents a very compelling opportunity to cultivate understanding, to restore trust, and craft outcomes that align with fundamental values of fairness, equity, and integrity that are intrinsic to the spirit of sports. At its core, mediation in sports disputes operates on the principles of empowerment and respect. Now, furthermore, the scope of mediation in sports disputes extends beyond the mere resolution of present conflicts. It encompasses the proactive cultivation of a culture of conflict prevention, constructive dialogue on continuous improvement with the sports ecosystem. Now, when I was discussing with some of the students who have come here, including Sadia, so we were talking about, how we have forgotten, because our South Asian culture of dialogue is completely forgotten. We are so invested in the colonial heritage of litigation that has been given to us by our colonial powers that our advocates refuse to look at mediation with the kind of respect that it really deserves. So that is something perhaps I may get an opportunity to speak in the panel discussion. So by integrating mediation processes and principles into the fabric of sports governance, the proposed council can proactively address potential areas of contention, enhance communication channels, and develop mechanisms for early intervention on emerging disputes. This proactive approach not only mitigates the disruptive impact of conflicts, but also cultivates an environment where conflicts are viewed as opportunities for constructive dialogue, learning, and growth. In the contemporary landscape of sports, the relevance of mediation in disputes is further accentuated by the dynamic interplay of legal, ethical, and commercial dimensions within the sports industry. The multifaceted nature of sports disputes often entails complex legal considerations, ethical implications, and commercial ramifications that actually necessitate a nuanced and holistic approach to resolution. Now, here's where mediation, with its flexibility and adaptability, serves as an ideal forum for for dealing with the legal complexities, the ethical dilemmas, and the commercial interests in a manner that aligns with the overarching principles of fairness, ethics, and sustainability. Now, this integrated approach is particularly pertinent in high-stakes sports disputes where the ramifications of adversarial legal proceedings can extend far beyond the immediate parties involved, impacting the reputation of athletes, the integrity of competitions, and the trust of fans and sponsors. In addition to its intrinsic value as a sport dispute resolution mechanism, the scope of mediation in sports disputes also aligns with the broader imperatives of social responsibility, ethical leadership, and inclusive governance within the sports industry. By embracing mediation as a preferred avenue for dispute resolution, sports organizations and stakeholders demonstrate a commitment to upholding ethical conduct, fostering transparency, and promoting the values of equity and social justice. This commitment transcends individual disputes, signaling a collective dedication to nurturing a sports culture that is grounded in integrity, respect, and accountability, values that resonate not only within the sports arena, but also in society at large. As we deliberate on the scope of mediation in sports disputes, it is imperative to acknowledge the inherent complexities and challenges that accompany the integration of sport mediation into the sports landscape. While mediation offers a wealth of opportunities for constructive conflict resolution, it is crucial to address prevailing misconceptions, build capacity, and establish robust frameworks for the effective implementation of the mediation process within the sports domain. This necessitates concerted efforts to raise awareness, provide training, and develop specialized expertise in sports mediation, ensuring that the practitioners possess the requisite skills, insights, and cultural fluency to navigate the unique dynamics of sports disputes. In conclusion, the scope of mediation in sports disputes represents a transformative frontier in the evolution of sports governance, ethics, and conflict resolution. By embracing mediation as the cornerstone of dispute resolution, the sports community can transcend adversarial paradigms, foster meaningful dialogue, and engender lasting solutions that resonate with the principles of fairness, sportsmanship, and inclusivity. As we look at the future, let us collectively strive to elevate the role of mediation in sports disputes, recognizing it not merely as a pragmatic tool for resolving conflicts, but as an embodiment of the unwavering commitment to the spirit of sports as a unifying force that transcends boundaries, differences, and discord. We have countries here, we have India, we have Pakistan, we have Bangladesh, and we have Sri Lanka. Many times we are not able to politically see eye to eye, but here we are sitting and playing the game together. So that is what sports is all about. And to resolve sports disputes, I cannot think of a better way of doing it than through the process of mediation, because it reflects what exactly sports stands for. Thank you very much.
Thank you, sir, for those thought-provoking insights. Next, to share his wealth of knowledge on the topic of arbitrating and mediating in sports disputes, I would like to invite Mr. Hiran Dialvis, attorney at law, legal counsel, and arbitrator with well over 35 years of practice in civil and commercial litigation, with expertise in several legal disciplines such as international arbitration, banking and company law, finance, leasing, family law, and fundamental rights. Mr. Dialvis is presently the chair of the Chartered Institute of Arbitrators London, Sri Lankan branch, as well as the chairman of the board of directors and the chief legal advisor for the Sri Lanka National Arbitration Centre. Please join me in welcoming him to the stage.
Good evening, ladies and gentlemen. Glad to see a gender-friendly audience, and especially our young sports enthusiast law students as well. So the topic actually assigned to me is to focus on arbitration and mediation in relation to sports primarily. So now, as you know, sport now is not merely a game. It is an industry. So it is vital then for any industry to have an efficient dispute resolution mechanism. So in that context, I think my previous distinguished colleague also mentioned, one is mediation, one is arbitration. And just my thoughts on this matter, I think there are various forms of dispute resolution. Litigation is one, it doesn't come here. Mediation is one, arbitration is one. But I want to emphasize humbly, with my experience and knowledge, each one is different and each one is good. If you try to marry and interface these together, I think there will be a problem. So as in any dispute, you meet, try to have a chat, talk it over. If you don't, you go to the next step. So that is why if you see the dispute resolution mechanisms developed by man, these methodologies are there. So now, strictly in relation to sports, arbitration and mediation are the primary methods of resolving disputes, unless of course there is a criminal element, which of course does not come under arbitration, possibly doping, which my friend Pandukos, who comes later, might allude to. So, distinguished members of the audience, you and I have something in common, I think, or most of you all. We all love the game of cricket, and we are all in the legal fraternity. So I think some of the batsmen have walked out to take a breather, so I was told by the conference chair, but I'm sure they will also agree with me that it's a wonderful combination, and let's exploit it. And also happy to address this conference and a bit of a tidbit cricketer. It's great to see some of my cricketing pals in the University of Colombo. Teja Silva, who played with me, is one of your principal organizers. Then Mr. Piyal Munasinghe, who is presently the chair. And there was Lasanta Mudilike, I think, who played. So I think I was one of the few who actually did not play lawyers cricket. Teja Silva was trying his best to get me to come and join. I said, if there's post as a baggage boy or a scorer, I will be there. So it's a pleasure to be here. And also, with the godfather of lawyers cricket, Mr. Santana Krishnan, without you, I think this would not have been possible. So thank you. And we are very appreciative of what I think the initiative you have taken. Right. Now, what are the disputes that you have in sports? Except for the mundane, I will just, to make it interesting, on a weekday afternoon, if you are timed out in betting, is that a dispute? Sri Lanka produced a, I think, world first maybe. Angelo Matthews got timed out. So the question arises, is there a, did he have an appeal? Is there a right of appeal? And what is the time period? Point is going back and getting a result 2 days the match is over. So leave this in your mind. I'll come back to that. The term, how's that? Bowler says, how's that? Is that an appeal? Is that a legal appeal? Umpire's job is to look at it and give his decision. Why should the fielders and the bowlers call how's that? Is that another form of appeal? Rugby World Cup, those who are rugby enthusiasts, I think the TMO where the All Blacks captain was sent off on a TV umpiring decision. Such a close match, such a important result, and the TV umpire said he's out of the game. Was there any recourse? Immediate recourse? Some other disputes also going on. Actually, when you look into this topic, we have this in Big Bash or something we had a fast bowler called Tom Curran who ran into the, I think, umpire before the match. And he has been suspended apparently for 4 matches or 5 matches. It's another dispute there. Matches going on. Interesting matches going on. Pakistan. Wicketkeeper Rizwan given out. Caught. So he says it's a wristband. Pivotal moment of the match. Thereafter, at the end of the play, they says, yes, it is the wristband. Was there an appeal? Should in sports have an immediate appeal? Then we go to the other well-known things. For example, that shows the opportunities in this area. That's why I said it is also an industry. Whether franchise league cricket prevails or the test match tour program prevails. Immediate dispute going on. I think South Africa is going to India with a second tour team. They are bound by their contracts to play the South African T20 league. Now, if a player wants to decide where he plays and is bound by that contract, is his right to employment violated? Or in a Sri Lankan context, we have a fundamental rights jurisdiction, whether your right to trade is affected. So these, I think, are areas which can give our mind to. Broadcasting rights, very well known. Mr. Dinal Phillips and I had some experience together long time ago. I must say, Mr. Dinal Phillips is excellent company. So, apart from the case. And so all of you know that broadcasting and television rights are a multi-billion or multi-million-dollar industry. So how are the disputes resolved there? As everybody knows, it's by arbitration. And some parts of this arbitration, in fact, in relation to that case, I must say, without naming parties, we had cricket in Sri Lanka. Television rights were for Sri Lanka. Contract says law of Wales or something. Dispute resolution in Singapore. I don't know who benefited. Ultimately, halfway we also had to come back. So, I think it's time to look at these areas, and look after our interests also. Then again, player contracts, as you know, it's well known. New things are coming, spot fixing, match fixing. How do you resolve those disputes? ICC rules are governing certain disputes. MCC, the private club, lays down the laws of cricket. Now in the present context, with billions watching in South Asia, they will justifiably ask, what on earth is this Marylebone Cricket Club laying down rules? No disrespect, they have done a brilliant job over 100 years. I mean, it's a wonderful example, but on what basis do they have jurisdiction over the sport that is played here? So, cricket is now not only the English forward defense. From the reverse sweep to the scoop, to the deal scoop. So, cricket is from here. So, even in dispute resolution, we must look at our strengths and also, of course, learn from the strengths of the others. Just to allude to the other sports, the same disputes, for example, transgender rights in athletics. Now, it's becoming hot area of concern when the people are running. Now, that possibly is an area where mediation might come in very, very useful, because you have to look at the rights of the runners, not to embarrass the people. And I don't think there you can take a quick decision. So the detail, that possibly is an area and we can do it in confidence. So that is one area. So those are the various forms of disputes I want you to give your mind to, and how we can come up with innovative ways of resolving these disputes. So, going back to the topic, the two distinct forms of dispute resolution. One of my favorite sayings in relation to arbitration is from a British judge, John Donaldson. He said, arbitration is private sector dispute resolution. It's from a judgment. Arbitration is private sector dispute resolution, where you have the court system adjudicating on disputes. These private contracts are decided. What he says is private sector dispute resolution. Now, why I want to emphasize on that point is the essential ingredients of dispute resolution has to be there in the dispute resolution process. You can't have shortcuts or hearing only one party, etc. So that is where my thinking that mediation is a slightly different form of dispute resolution. Of course, I don't agree that never the twain shall meet. Now you can say they are meeting, which I will come to later. But I want to emphasize the point that there is an arbitration mechanism and there is a mediatory mechanism. Now, most sports disputes, as you know, are governed by these alternate dispute resolution mechanisms, especially by arbitration. Now, the previous speaker also referred to the case, so I won't go to that in detail. But you can see that even in the Court of Arbitration for Sports, so it's a Court of Arbitration for Sports. It is possibly the most recognized form of arbitration for sports. So that is its primary function. However, if you look at the rules, a mediation process is now also specifically referred to. And I think it says, if I may, parties may have recourse to arbitration when a dispute has not been resolved by mediation, provided that an arbitration clause exists. So again, you go to the mediatory process, the clause provides if there is a non-settlement, then you go for arbitration. So that is there in Court of Arbitration for Sport also. Now, again, let me go to the instance of the suggestion, should we have an independent dispute resolution mechanism for sports in our region? I think we can do it, and I think we should do it. There have been various discussions on this point at various forums. I think with Mr. Santhanakrishnan's initiative and us being there, I think it's time to look at this very, very seriously. We have very good cricketers in this part of the world. And we have very good professionals in this part of the world. Why can't we do it? Except for when we are playing the opposing country, we like to see Sachin Tendulkar or Imran Khan, or admire the Bangladeshi and Afghanistan cricketers, what they are doing now. So they have really developed the sport. Same way in dispute resolution, we have very well known and highly respected dispute resolution people in the field. So with over 1 billion people playing this sport, I don't want to make comments on countries. How the dispute resolution mechanisms are in an area where not even 0.001 of those countries do the sport is beyond belief. So I think high time we take that initiative and go forward. Of course, going forward, the essential preconditions have to be met. I will come to that later. Now, the speakers also referred to the why Sri Lanka, if I may. just give a background to the dispute resolution history in Sri Lanka, especially to our foreign guests. Now, Sri Lanka, as one famous jurist, Dr. Veeramanthi said, our jurisdiction has been referred to as a very colorful mosaic. We have laws springing from diverse as England, Arabia, the Gangetic Plains, side by side. They are jostling for recognition for legal heritage coming from Rome, Netherlands, and our indigenous customs. Then we had the introduction of Buddhism into this country in the 3rd century BC, which really evolved into this system of a village headman or the village elder resolving disputes. So it's a different form of mediation and conciliatory approach that is very well ingrained in this country for over 2,500 recorded history. Then through foreign influence, we have the Portuguese, Dutch and legal regimes. So we are one of the few countries in this world, we have the Roman Dutch law in certain areas of our law, which is actually our common law. And in minute areas of contract law, of course, the Roman Dutch law applies, like the principle of unjust enrichment. Then in relation to commercial matters, since we are talking about contracts, we had an ordinance in 1852, which introduced the English law for commercial and business matters. So rest assured, in relation to all contractual matters, actually, it is something very, very similar to the English law that is applicable in Sri Lanka. So, as a judge once said, a Ceylon court of justice is actually a British court of justice. So familiarity is also there in this region for people to embark on this journey here. Then in relation to arbitration, very few know that we have arbitration ordinance originally in 1856. Thereafter, being a dualist legal system, we signed the New York Convention, 1962, and we have been a party to that from that time. So we have a long history. Then based on the model law, we had a new Arbitration Act, 1995, which is a very good act. Also, this led to a dramatic growth of, especially after the opening of the economies in 1977. Even presently, I was a member of Ministerial Committee for Reforms of Arbitration Laws. So significant drafts, suggestions have been made for strengthening interim relief, expediting the process, preservation of assets, etc. We are waiting for that to come to Parliament. So that is the background. Apart from that, slightly off thing which, for example, we have a thing called the port city that is coming offshore. Now, if you read carefully, there are certain strategic investments that tax reliefs are granted. So I said a few days ago, I think a highly sophisticated hospital is being set up. So possibly the investors want some tax relief. Now, according to what I have been informed, one of the principal reasons that Dubai was offered the ICC's dispute resolution hub was the tax benefits that it offered to maybe the employees or whoever was using that system. I think British government refused to give the tax exemptions. So this is an area which we possibly can discuss even with the state authorities and with our dispute resolution bodies to see if there is an independent, internationally recognized dispute resolution center to attract that business with a certain legislative or taxation benefits can be negotiated. I think the discussion definitely can be open. So that will be a strong impetus to go on this route. Then coming to specific arbitration models, we have a couple of centers in Sri Lanka which have wide and varied experience in this field. apart from the Arbitration Act of 1995, these centers also provide for ad hoc hearings or arbitrations based on their rules. So for example, the center which I am on the board recommends the UNCITRAL rules. We have also developed a hybrid approach for an expedited rules mechanism based on the UNCITRAL rules. That is one we wanted to share that with you. So that possibly is also an eye-opener as to taking this step forward of having very efficient and fast dispute resolution mechanisms for arbitration in this part of the world. So, as I said, in these specific disputes which I referred to, that's why I want to give a mind to that, you will see speed is of paramount importance. Speed, I think, is on paramount importance in sports dispute resolution. As I said, if it's the timeout, if it's the TMO, can only the umpire decide. Should that player or the team have a right of recourse for appeal? Can the appeal be instantaneous? Can with technology, with a certain time period, a monitoring body at an arbitration center give a quick decision? Maybe in a couple of minutes. Can that be done, and shouldn't that be done? So, speed is sine qua non. Of course, the ingredients of efficiency, integrity, and enforceability is essential. That is also essential. The dispute that is referred to has to be decided effectively. Now, as I said earlier, this is also an industry. Industry means ideas. There will be clashes. There is nothing wrong in having clashes or disputes. It is how you resolve them that is key. So if we can think of moving forward with a very efficient, very impartial, independent dispute resolution mechanism, I think we will be taking a big step forward. So, I think Colombo is that way well placed. We have the location. I think travel from any part of the world is not an issue. The essential language skill for the dispute resolution process is there. The love for the sport is there, especially cricket. As I referred to, the legal heritage is there for Sri Lanka to provide the background to this. And I believe that at the moment, we are non-aligned and there is wide acceptance with all our good friends, especially in the SAARC region. And we can offer a neutral venue. Now, I emphasize neutral venue. That does not mean it need be run by the Sri Lankans themselves. This can be the venue. It can be a joint venture. And I think it's an ideal mechanism. We were addressing the SAARC Arbitration Council seminar in Colombo about maybe 3-4 months ago. Here we are talking about sports. We were talking about the enormous possibility of trade, cross-border trade in that region. You have 1 billion in India, one of the fastest growing economies. We have, I think, over 100 million in Bangladesh, close to 200 million in Pakistan. We should not be fighting. We should be prospering. So I think time to look at this broad-mindedly, and we have things that unify us, like cricket, like our legal heritage. We have the arbitration laws in all the countries. We have the mediatory approaches in all the countries. So I like to leave you with those thoughts, and maybe the panel can follow up with that deliberation. And to the cricketers who are here, enjoy the cricket. Thank you.
Thank you, sir, for that future-focused outlook. We will now take a short 20-minute break before reconvening for the much-anticipated panel discussion. I kindly request that everyone is back in their seats after 20 minutes. Thank you.
mic in the wire, and the panelists can have one FM mic. FM mic එක එකක් ඕනේ. Can we test the FM mic? Can we test the FM mic? Can we test this FM mic? Testing. What are we going to test? FM mic. 1, 2, 3. Testing. 1, 2, 3. Okay.
Khan Associates. His main area of practice includes, amongst others, corporate governance and commercial law, arbitration and mediation, sports law and intellectual property law. He represents various financial institutions, aviation companies, regulatory bodies, energy resources-based companies, and more. He has been the retained lawyer of the Bangladesh Cricket Board, BCB, for over a decade and represented BCP in the first sports arbitration conducted in Bangladesh. He's also a member of the Project Implementation Committee, PIC, of the Sheikh Hasina Cricket Stadium, CHCS, being constructed by BCB. Please give him a huge round of applause. Last but not the least, Mr. Sayan Mukherjee is a legal practitioner enrolled with the Bar of the Honorable High Court at Calcutta, India.
And thereafter, it was submitted to the parliament, and we brought the national sports policy in 2012. In the sports policy, we have very specifically mentioned that Sri Lanka should be a independent arbitration center in the Asian hub. So what we have done is, now the parliament has approved the basic approvals. We are planning to implement this in 2024. Already we have discussed with the Honorable Attorney General in Sri Lanka and also legal draftman in Sri Lanka. And we are preparing the constitution for sports arbitration to be held in Colombo for the Asian region, and it will be an independent international arbitration center. And we have all the infrastructure facilities, the hotels, and also, as we know, the Colombo city is trouble-free, tourism-friendly, and also so many sports are there. In Sri Lanka, we have over 76 sports bodies, and especially in cricket, football, rugby, and also athletics. Sri Lanka is participating in SAF games, Asian Games, South Asian Games, and also the Commonwealth Games and the Olympics. So we as a country is looking forward to implement this law in 2024. It's, at the moment, it's in the draft stage, that by another 6 months down the line, we should be able to implement the sports arbitration, all the laws, and also we should be able to implement this International Sports Arbitration Center.
Thank you, sir. We now move to Mr. Dinal, sir. If you could just give a glimpse of what is your opinion about this, sir.
Yeah, hello. I'm at slight variance with what my friend Panduka said, because going through the net the other day, I find that there was a decision to set up a sports arbitration hub in 2015 by the then Minister of Sport. And I did have a word with him only yesterday. And he said, yes, that had been done. And there's a draft already with the Attorney General's Department. So I spoke to SG Sumati Dharmawadana, who said, yes, that was done way back then. And it's gathering dust in his office. So if we speak to him, he can fetch it out and tell the AG to cooperate with us fully on this.
By the sports minister, because he has the legal coverage to appoint. And thereafter, we should be able to revamp that draft and get it passed in cabinet. Thereafter, we have to go forward. So that's why I said down the line, another 6 months' time, we should be able to implement this law covering all the international rules and regulations and their ethics. And also, it has to be approved by all the international sports bodies. That should be the basics for the arbitration. And also, we have the legal fraternity over 250 years of great British law and also the common law in the country. So it is very, there's a huge advantage, not like in most of the Middle East countries. So I think the Indian sector is also close by the Pakistanis, and also we are very proud to say that the anti-doping law was implemented in Sri Lanka for the first time in 1993, Act number 33 of 1993. And also we have the laws of sports corruption law in Sri Lanka. That was implemented in 2019. So we have signed the charter, the Olympic Charter, the UN Charter, and also all the other international bodies. We are affiliated with that. So there won't be any problem for Sri Lanka to have an independent sports arbitration to function. Only thing is, as I clearly mentioned, we have to implement this law and to go forward.
Since you're always walking the corridors of power, Panduka, can I put you in a spot to fast track this committee? So there's a clear undertaking from Panduka that he'll fast track this.
I should be able to fast track, since the minister, I have spoken with this with the Honorable Minister of Sports, but we have to go through the proper procedures. If we bypass any procedures, then there will be a issue basically. So we have to go through, and we must give the South Asian Center and be implemented. So that's why we say another 6 months' time we should be able to implement this. But I think I totally agree with you, Dinal. We had to fast track. Actually, this is called the MICE tourism and the sports tourism. If we have the sports hub and the international arbitrations center for Sri Lanka, we should be able to attract the events as well as the arbitrations for sports. As we know, IPL is there in India, and most of the Asian games are there, SAF games, and this is Sri Lanka, Pakistan, and Bangladesh. So why not we have the arbitration in South Asian region, rather than we go to Lausanne, Singapore, or even Dubai and play $50,000 or $100,000. We can have, I think, 10% out of that cost. We should be able to complete the arbitration and go forward. I think it's very viable, and also it will be very economical also.
Thank you, sir. Before we proceed towards the specific questions addressed to the panelists, if Mudassar could share a few thoughts in brief.
Thank you very much. We all know that every state has their unique way of resolving governance and regulation in sports aspects. So like most of the Southeast Asian countries, Bangladesh, the Ministry of Sports as well as the National Sports Council is vested with the mandate to regulate the sports and the development of the sports. And the National Sports Councils have their national sports organizations affiliated with them, and it is through these organizations that the autonomy of sports is meant to be regulated. Say, for example, Bangladesh Cricket Board, Bangladesh Football Federation, the hockey federations are there. So it's very easy for us to, I think, to deal with the aspect of setting up a tribunal in Sri Lanka or elsewhere within this region. First of all, we need to understand and appreciate that we need to take a more holistic approach. As much as it is true that the cricket is overwhelming or the majority of the sports that is played here, but we need to also take into account the other sports, the football, the hockeys, the athletes. We must take those into consideration while dealing in setting up a tribunal here. So, for example, for as far as we were concerned, even 20 years back, whether sports law existed was a myth. Unlike Sri Lanka, who seems to have their own set of sports law, we don't have any particular statute or legislation there. So even today, if there is any issue of anti-corruption issues pertaining to sports, we may have to resolve to penal code for some sort of relief. We don't have any law that says the standard of proof or whether it is quasi-criminal, civil, or criminal in nature, all these things. So we need to get those in place. We need to take the sports as a whole, and then we need to think about how we can get those stakeholders involved in ensuring that a tribunal could be set up in this region. See, I think when CAS was set up, IOC had a role to play. Maybe when, so far as setting up a sports tribunal in this region, maybe we could use each of the state has to come forward, the government has to show that interest. Then maybe in terms of from a platform, maybe we can use SARC as a stepping stone, which would ensure that all the national sports organization within this region would also come into play. So, and there would be the support within each other, and only then we would be able to set up a separate tribunal within this region. Once it is there, maybe the respective sports organization can bring into the respective anti-corruption code or the doping code as to the forms of the tiers of appeal, and which is there. And maybe the finality of the appeal stage could be that particular forum, whether that's in Sri Lanka, or maybe that could have a headquarters somewhere, and maybe it could function from various places in this era. So it need not be localized into just one place. Maybe it could have a headquarters somewhere, and maybe it could function from various regions. Because, say for example, if there is an issue about any particular franchise league in any particular sport, and the parties involved there are the national board and the athletes from that particular community, it only makes sense that the whole thing is conducted within that particular jurisdiction with the support of that tribunal. So if that center is there, and if the logistics and the technical know-how and the legal expertise is there, and if that could be exported for that particular reason to that particular jurisdiction, that would go a long way in terms of saving money, not only for the boards, but also for the athletes, which is of paramount concern. Because here, the athlete is an individual, whereas the boards are an institution. So in terms of financial capability, that disparity would be there, of course. So we need to keep an open mind so far as setting up a tribunal is concerned. As I said, it could operate from one place, or it could have a setup somewhere, and maybe it could operate from different region as well. Thank you.
Jawad, sir.
Yeah, thank you, Ashok. How I see it is that there are three elements that need to be satisfied to have a place as a center for setting up a tribunal in this way. So first would be the accessibility part. I think for the Asia Pacific region, Sri Lanka is a relatively easy country to reach from any part of the Asia Pacific region. And the visa formalities are much easier here. And it's also a safe country to come to. That's one aspect. The second aspect would be the infrastructure. And I think there are enough opportunities here to set up the right kind of infrastructure with the right kind of investment for running a tribunal of this nature. And the third aspect, as Mr. Panduka also pointed out, is the cost factor. Because justice should be accessible. It cannot be out of reach for somebody, imagine going all the way to Switzerland to agitate some right of yours that would have been violated. For an athlete, it's impossible. So from the cost perspective also, I think Sri Lanka is a very ideal place to have from all these three elements as far as I can see that. Thank you.
Thank you, Ashwath. Coming from Jawad sir's argument, so here I feel that we need to address three major questions, the golden questions which it is. Why this setup is necessary, and how this setup is possible in this venue or the seat, and what we are looking at. So these three questions are to be discussed in proper resonance with each other, so that this can be addressed, and the access to justice is also a human right. So all the athletes are basically having their human rights secured when we are dealing with such an institute. So let us then equate the rule of law with the rule of game, like we are doing it here in the Lawyers Cricket World Cup. Thank you.
Thank you, gentlemen. So, in order to have a tribunal set up in Sri Lanka and to be at par with CAS, which is the Court of Arbitration for Sport, one needs to understand what is CAS. For the audience, the young students who are over here, we have Sayan, who, if Sayan could help us understand how CAS functions and why and what has made CAS the most reliant body to settle sports-related disputes for over decades.
Thank you. So we are playing this sport, cricket, for friendship, which our motto is, as a leisure activity. Now, in the globalized world, this entire thing has taken a mammoth transformation. People have ingested huge amount of money, for which this commercial industry has turned into the sports. And CAS, as we may discuss from the panel, so this CAS was formed in 1982 when the IOC had placed this main idea of setting up a commercial tribunal only for settling disputes relating to sports. This CAS was initially formed through a statute, which is the Code of CAS, and that came into force in 1984. Now, two bodies was established. Firstly, the International Council for Arbitration for Sports, which is mainly the administrative wing of the court, and secondly, the Court of Arbitration for Sports. Initially, there was a dispute because the Court of Arbitration for Sports that relied financially upon the International Olympic Committee. So that was appealed in the Federal Supreme Court of Switzerland, and a separate body which would take care of its finances was created as a registry office, which operated as the International Court of Arbitration for Sports, ICAS. Now, this CAS, it had its headquarters in Switzerland, only because that the IOC was seated at Switzerland. Gradually, with time, this bench had been given two circuit benches, one in New York City and the other one in Sydney. So the access to justice was bifurcated to three parts of the world. Coming to the arbitral awards which are passed by CAS, all the arbitral awards are appealable orders in terms of the territorial jurisdiction. When CAS passes an order, it may be appealed before the Supreme Court of Switzerland. Now, the jurisdiction of CAS has threefold major heads. Firstly, it has the ordinary jurisdiction, which is the original jurisdiction. In any arbitration agreement, if there is a specific clause that a dispute may be resolved by taking it through CAS, then this agreement will equate the dispute in the Court of Arbitrations for Sports. Secondly, it also has an appellate jurisdiction, where the the internal remedies which are available to a sports person or any stakeholders to a sports dispute, he can go to the internal committee. For example, a disciplinary committee may be set, and thereafter, the internal committee gives it to the appellate committee within that federation itself. And the federation, after the appellate committee passes a word, it goes up to the CAS. So again, the access to justice is bifurcated and diverted to Switzerland, which is again cost. Cost is a major factor there. But why CAS has gained so much of popularity in this globalized world? Firstly is the flexibility of CAS. You don't need a lawyer to represent yourself in CAS. You can have any person represent yourself. Even the person in person can go and appear before CAS. and most importantly, the time-bound justice. Rule 59 of the CAS code, procedural rules, it establishes that when a file is transferred to CAS, they only have 3 months to dispose of the file. It may be extended to a certain period of time, but this time-bound justice is an essence of any sports-related arbitration, as already covered by the panelist who spoke about this. And concluding that the code discussion can further the difference between the commercial arbitration and sports arbitration, because there has to be a subtle difference, because in commercial arbitration the New York Convention is applied, but in sports arbitration the internal regulations are there for each of the federation, which needs to be adhered to before the arbitral proceeding is given an effect. So this may be looked into in the further discussions.
Any famous case laws which the audience would like to know of CAS?
Right. So most of the cases have been discussed by Dinal sir very elaborately. I'll just break this segment into 3 broad heads. Firstly, about the jurisdiction. Now coming to the independence of CAS, which is one of the reasons of its popularity. Jurisdiction is something which is, has to be independent and not intervened by any court proceeding. So we have a case law here which has the citation of CAS 2006 A1190. You all must have been aware of this. This is the case where famous cricketer from Pakistan was, 2 famous cricketers were involved. So the PCB had passed a verdict relating to anti-doping. That was taken up to the appeals committee within the PCB. And there it was held that honest and reasonable belief that the supplement ingested by them did not contain any prohibited substance. So the intention which Sir was speaking about in the keynote also was taken into considered, and the ban and the sanction which was imposed, that was lifted by the PCB appeals committee on those sports persons. Now WADA intervened and filed an appeal before CAS. Back in 2006, this PCB did not have any regulation which imposes that any appeal has to be preferred to CAS. And even the ICC did not have any mandate to any of its affiliated federations that a cricket dispute has to be appealed against to CAS Switzerland. So CAS regretted that aspect, and it had to consider that it did not have the jurisdiction to pass an award in that case. So here CAS was specifically given a guideline that the ICC and all the federations may frame a proper anti-doping rule so that they are complied with and the strict liability policies are maintained in anti-doping cases. Now again, Indian boxer who refused to take the bronze medal in the Asian Games in 2014, that case was ruled by CAS, and a sanction was given on the Indian boxer, female boxer, and that athlete had preferred a public interest litigation before the Delhi High Court. However, Delhi High Court again declined to intervene with any of the rulings of CAS, maintaining and assuring the independence of the body. So this is how CAS is also maintaining its autonomy, and it is establishing itself in the world. So people are relying upon it as a precedent. Now, mostly anti-doping cases have been covered by Dinal sir, so I'm not going into that. An interesting thing which the audiences may be interested. So there's a new dispute which is about differences of sexual development. So in 2009, the racer, a female racer, who got a gold medal in the World Championship. She was later on discovered to have some hormonal disorder which caused high testosterone in her body. So that again initiated a discussion about differential sexual development, especially with regard to gender-specific sports. Now, International Amateur Athletic Federation has framed certain rules regarding this DSD rulings. So that has been covered mostly, and CAS also affirmed these rulings so that DSDs may be considered in the future Olympics and future games, which are gender specific. Coming to commercial disputes, CAS is also dealing with commercial sports disputes. As we know that sports industry has been commercialized, and all the franchises are going into huge investment of money in the sports industry. Two of such cases are the Manchester City banning case, which involved around 30 million euros in the, and one of the most important debacle in football history was Michel Platini's ban. That was in 2011. So there also, yes. Sir.
Has the Man City case been reopened again?
Sir, the Man City's case was reopened in 2016 by UEFA, but the CAS overturned Man City's 2-year ban from European competition and reduced the club's fine as well from certain million euros to 10 million euros. That is the latest position of the case laws.
Okay. Thank you, Sayan. Before we move to Dinalsa and Panduka, sir, to understand the developments to be made in Sri Lanka to have a separate arbitration tribunal, Sayan, could you just conclude by just giving us an insight to which countries already have an independent tribunal?
Right. So most of the tribunals which are established across the world are country specific. So and it also has been recognized by each federations involved within the domestic circuit of the countries. USA has the American Arbitration Association, AAA, where the US Olympics Committee as well as US Anti-Doping Agency has given the responsibility to administer and resolve disputes relating to sports to this institute. UK has a private setup where sports resolution is conducted through an independent body where there are around 1,700 disputes resolved in the past 10 years. Now, coming to China, they have recently amended their law of People's Republic of China on physical, cultural, and sports-related issue in 2022. This has empowered the General Administration of Sports of China to have a separate independent institute to resolve disputes. Japan has an establishment since 2003 where Japan Sports Arbitration Agency, JSAA, has the responsibility of settling disputes. Similarly, in Australia and New Zealand, there are separate institutes. And interestingly, New Zealand has a setup where, apart from the arbitration body, there is a separate body only for mediation, privatized sport and recreation complaints and mediation services in New Zealand. That was set up in 2021. So it only takes up complaints and tries to adjudicate it through mediation.
Thank you, Sayan. So now we move to Dinalsa and Panduka, sir. Now, after having heard of how CAS functions and what has made CAS so reliant over the decades, Dinalsa, is it possible to set up a tribunal like CAS in Sri Lanka and eventually attain the popularity and effectivity the way CAS has attained over the years?
The short answer to your question is a resounding yes. All it needs is technology is available, and cost is half the cost or even less than going to Lausanne. And you need a center. We have a center already. One of the center heads are here. And all you need is a bit of seed capital to start it going. Of course, one thing I did notice seeing the CAS procedure is they have it about 3 or 4 languages there. Am I right? 4 languages, isn't it? So maybe to attract Spanish, English. So maybe we should look at that. And I think Panduka, you're the best man here for that. Because once I was dreading it when I was first told to get this thing going. We didn't know that there was some sort of work already, some spade work done. So we really don't have to reinvent the wheel, so to speak. So now that something is already there in the pipeline, the sooner we get it off the ground, the better, because I believe in October we'll be rather busy otherwise.
Panduka, sir, how can we actually formulate the entire process of setting up a tribunal, and how to start an independent tribunal in Sri Lanka? What could be the preliminary steps that we could take in order to attain this? And what could be the potential timelines to have this achieved?
Actually, as I told you earlier, we have already got the approval from the Parliament of Sri Lanka. That was passed in 2012. May 16th, I have the gazette with me. It has been unanimously passed by the Parliament. In that clauses, there it says that an independent tribunal for sports, an independent tribunal and an arbitration board will be set up to inquire into dispute relating to sports, right? And it goes on. So what we have to do is, we have got the approval, preliminary approval. We had to set up the committee, and that has also done. We, as the Additional Solicitor General mentioned to Mr. Dinal Phillips, President's Council, we have done a preliminary draft. So we had to revamp that and bring it to the Cabinet of Sri Lanka. And also it has to be par with the international sports laws. And we must make sure it is an independent arbitration center, that no interference, no political law, any other interference. So that setup has to be done. And to go forward, I must tell you one more thing. Now, when it comes to World Anti-Doping Agency, in Asian region, there are only 3 testing labs. One is in New Delhi. Please correct me if I'm wrong. Another one is in Qatar. The third one is in Japan. Now, recently, World Anti-Doping Agency banned the Indian New Delhi testing lab, 2019. There also, Qatar also the similar thing happened, and they have again come back. So even to do, with regard to the anti-doping rules violation, any athlete wants to test the
Panduka, just to interrupt you,
yeah,
both those laboratories found 2 Sri Lankan athletes guilty of violating anti-doping.
Exactly. And my respected friend took up the challenge at that arbitration, saying that the results are not accurate. So the benefit of the doubt was taken, was considered, and they were acquitted from the charges. The reason why I want to tell you is it's very expensive to have testing labs. Only the international, in the Asian region, the international standards are being maintained by Japan. Even similarly in Kuwait, similar thing happened and they had to shut down. So we have a problem. So when it comes to corruption in sports, perfect, we can handle this. If it is a doping rules violation under the WADA, we have only 1 lab in the Asian region. Others are being challenged by most of the senior law fraternities in the Asian region. So we need to have at least few labs. That is a area where it is lacking. Sri Lanka can't afford to have that, because at least to have international testing lab, we need to have at least 1,000 to 2,000 testing has to go for a month. Otherwise, it's not practical. We can't.
Just to interrupt you again. So can't WADA, with their vast resources available, okay, if there are some shortcomings in certain laboratories in India or Doha, okay, regularize them and tell them these are the standards.
Yeah, it has to be affiliated with the WADA regulations.
Sure. So they monitor it, they test it like say.
Yeah, that time to time they have monitored. So when they see that the testing standards have come down, they come and ban immediately. So once it is banned, if there are issues,
but the damage was done to our
damage
athletes.
is done to the athlete. So how many now in Sri Lanka? We implemented the law in 2003. We signed the universal agreement with the World Anti-Doping Agency. Our first athlete who got banned was, I can't mention the name, he was a boxer. He won the Commonwealth boxing bantam gold medal. Yeah. So actually, I was in the panel. We banned him provisionally. He appealed against the order. We went up to CAS, and finally he was banned. Thereafter only we found out that we should have a local law as well for anti-doping. So that's the reason, that was the main reason to have the act passed in Parliament, which is affiliated and par with the international WADA rules. So we did that in Act number 33 of 2019. So what I want to say is, these are the areas which is lacking. Proper testing facilities has to be there in Asian region. So for a player to test for doping control testing will cost about $300 to $500 sending to Japan. But half the price will be in Delhi. Now I'm also a member in the anti-doping agency in Sri Lanka. We normally conduct about 100 to 200 testing for 3 to 4 months. For a quarter of the year. So it's very costly for a Sri Lankan institution to do that. There are 76 sports federations. So we randomly check all these things. But doing the testing is very costly. So that's the reason why we are finding difficult. There are practical issues. But setting up the independent arbitration centers, setting up for CAS or whatever in Asian region or Sri Lanka is not a problem. We have better facilities than most of the countries, right? And we, as I told you, if we can have a proper and international standard testing laboratories for sports related matters, that is one that will be a great asset for the Asian region. Other than that, there are no obstacles for us to start. And I'm sure the Minister of Sports and Youth Affairs, and with the support of the Attorney General and legal draftman, and also the senior lawyers like most of the members who are here, and also Mr. Dinal Phillips, and also we should be able to get the Indian and the Pakistani and the Bangladesh expertise. We'll set up a committee and we'll go forward. And we'll try to do this. Thank
Ideally,
you.
Panduk, if we do a working draft, we can mail it to them and get some of their input.
Exactly.
And fine tune it.
I think the young lawyers like my son have a lot of experience.
Because
I'm very proud.
The sooner we get that doing, judging by newspaper articles, the better it is.
Definitely, we should.
Thank you, gentlemen. This is an open question for specifically for Dinal and Panduka sir. Considering that we have already the regulations of Sri Lanka, like the Sports Law and Regulation 1973, we have the National Sports Policy 2015, and we have the already existent Arbitration Act 1995. Given that we would want to set up a tribunal in Sri Lanka, which would be setting a precedent internationally, do you think we should be making any specific amendments to these already existing regulations?
That's what I told you. Actually, the sports policy is not 2015, it is 2012. Please correct that. Then, for the international sports arbitration, the Sri Lankan sports law doesn't come into force, because that is only for the Sri Lankan athletes, not for the Asian or any other. But whoever who is in Sri Lanka who is playing a game, then there are two laws. One is the anti-corruption law, that is called the sports-related law, which is coming into force. For example, if a two, India or Pakistan with Sri Lanka, they are playing in Sri Lanka, if any player or affiliated member get caught for corruption or doping or maybe match fixing, then the local law coming to force, right? But the sports law is only for the citizens of Sri Lanka, sports citizens of Sri Lanka. So we are going to have a new law which should be recognized with international sports bodies, International Cricket Council, Olympic Charter. Then all the arbitration clauses should be well recognized for CAS. So we will be drafting a proper international standard regulations to have the arbitration center in Sri Lanka. That's why we need about 6 months in the line, and we will implement that. And with the facilities what we have, we should be able to have this within 6 months.
Just to add on to what Panduka said, I think that's substantially correct. Because right now, as we speak, there's been a draft constitution already forwarded to the president based on the Chitrasiri Commission, which revamped the current Sri Lanka cricket constitution. That will be probably put to cabinet soon, and together with the sports law being amended, we'll have a brand new constitution for cricket, hopefully, and a brand new sports law which was enacted way back in 1973. I was a petitioner originally in that case together with some others to compel the minister to start amending the constitution. We had a lot of fun and games there, but it finally paid dividends. So it's all now in Panduka's hands with his connections to get the regulations done fast and the new amendments. I believe Jagat Fernando has also passed a concept paper on to amend the sports law, which has to be amended because it's absolutely archaic what we've got now. So up to you all now.
Actually, the sports law will be amended. Actually, we have already, there will be a new sports law coming up. That is for Sri Lankan sports personnels. And with regard to the arbitration, the law will be different. That will be implemented with the international sports bodies and sports regulations.
So the cabinet will be doing all sports now and nothing else for the country.
I don't want to talk about the politics here. I know my dear friend is pulling my leg, but I want to say is this. Let's think about the future. Asia is the pearl hub of the entire world, right? It's a wonder of Asia. We have done wonders in past, and now the cricket has come to a level where the Asia is #1 in the world. 25, 30 years ago when we were schooling, we were talking about Australian cricket and the cricket in London. Now we talk about Asian cricket and Indian cricket, right? So likewise, we are very much great in track and field, Asian level, China, Japan, most of the Asian countries. We are coming into the second, third place even in Olympics, in Asian level, well, in the world level. So therefore, it is a high time for us to have our own arbitration centers. Not only in Sri Lanka, why not in other countries like, India, maybe another area from Indonesia or whatever the countries. So let's have few international arbitration centers. We will do our best to have a international arbitration center in Sri Lanka, and that will have the impact for sports tourism, right? And this is the way to go forward. Thank you.
Thank you. Mudasir, now having represented several athletes at different stages of your career and coming from Bangladesh, could you give a perspective, an international perspective as to what could be the practicability of setting up a tribunal in Sri Lanka, and would the stakeholders be willing to recognize a Sri Lankan sports tribunal at par with CAS?
Thank you. Twofold question. As far as the second one is concerned, of course, if a tribunal could be set up in Sri Lanka, it has all the means, the technology, the monetary considerations, everything is in their favor. As whether or not it's going to be effective, it would depend on the mindset of all the stakeholders and their intentions. We need to look into this whole setting up a tribunal from two contexts. Number one is international, and the other one is domestic. So far as international regulation of sports are concerned, that involves ICC, FIFA. We don't have too much of motorsports here, so that the athletes, you need their consideration as well. But as a starting point, I believe we should start with our domestic approaches. For example, me and Mr. Dinal Phillips, we had the opportunity of doing the first sports arbitration that was held in Bangladesh, I think around 2014-15, or maybe a year earlier. And that related to a franchise tournament, and that was the first time we did set up a sports tribunal, and there were few practical difficulties that we came across, because for a region that did not have a sports law, for them to understand the concept of sliding scale of standard of proof, the evidentiary laws and the regular law of evidence is not applicable. Those challenges were there. So that's why whenever a tribunal is being set up, you need those that has to be supported by those expertise. Initially, when I spoke, as I said, we need a common platform in terms of the region. By all means, Sri Lanka could be the headquarters. Sri Lanka could be the place where the tribunal could be set up. But unless and until all the Southeast Asian region countries, the government, they think that, no, this is something we want. One of the consideration was we don't have a international standards testing center here, and it's not going to be cost effective for Sri Lanka to have it here. That could easily be circumvented if all the 7 countries or all the Southeast Asian countries come together. So we could have a MOU, we could have a convention, so that when a football federation tournament is being held and there is some sort of a anti-corruption code, anti-doping code, we could have the appellate tier here, and maybe through that platform, if that consensus is there, all the boards would be following that, because as I think he said earlier, that ICC did not have earlier unified domestic anti-corruption domestic code for all associate countries or test countries. They had one ICC anti-corruption code for the international matches, but when it came to the local ones, the local boards were they had some sort of, I think, leeway in setting up their modifying the anti-corruption code, but they had a standard template. But maybe that is changing now. But so if we had that kind of a standard anti-corruption code, anti-doping code that comes along with the tribunal or the boards, maybe that's one way and we can ensure that the tribunal is not only set up, it is acknowledged, recognized, and is effective. Once we have an effective, recognized tribunal operating, that is, even in the domestic sphere, to resolve those disputes, then we would have a stake in saying that even the international ones could be done here. So maybe that's something we could take into account. Thank you.
Just to add on to what Mudasa said, that was an interesting arbitration where I held in Bangladesh for the first time, and I was really impressed because we had to have two witnesses, one from New Zealand and one from the UK, and we are sitting right in the middle in Bangladesh. So the time was fixed at something like 2:30 in the afternoon, where we could dial up New Zealand, which was 8 o'clock in the night, and UK, it was 8 o'clock in the morning, and we got those witnesses down. It was quite an interesting experience for that. And then at the second stage of the appeal, my client, surprise, had a lot of money, so I had to make my submissions again from Colombo. So we set up a little setup section here in Colombo in my office, my chambers, and I made submissions to Bangladesh there through Skype. Back in those years. So it was quite interesting there.
Thank you. Thank you, Mudassir. Sayan, given that we are talking about setting up a tribunal in Sri Lanka, I believe there were talks going on for India as well a few years back. And could you just throw light on that and what went wrong?
Right. 2021, the Indian SAIC, Sports Arbitration Tribunal, was set up and headquartered in Gujarat. Now, that was mostly, only issue was about recognition. As Mudassir had said, domestic is the way to go for the initial setup. And if the international committees and the federations are not recognizing an independent tribunal beyond CAS, because it is giving the infrastructure ready-made right now. So that is the only issue which is pushing it back. And this can be furthered through an independent tribunal in the domestic circuit, which might give the way and establish itself as a establishment which renders adjudication.
Okay. Now we have spoken a lot about arbitration. Jawad sir, could you please throw some light on why probably, or if probably mediation could be the way forward over arbitration?
Okay, there are many reasons for it. See, if there is a dispute which is capable of being negotiated and settled, should it not be the first thing that you do? That's the basic question that we need to ask. Now, if the answer is yes, then the question is negotiation really easy? Because, when direct negotiation takes place between people who are in conflict, there are a number of issues that come up. There are biases, there is a lot of emotion, and many times the judgment gets clouded. So what is mediation? Basically, it's facilitated negotiation. So you get a neutral third party who's skilled, who's trained to facilitate the negotiation and to bring about a resolution of the dispute. So anything that is capable of being negotiated and settled is capable of being mediated and settled in a much better way. So the agreement that is reached between the parties will not have any kind of problems in it, because that would have been sorted out through the discussions that are facilitated by the mediator, who will help the disputing parties to look at the different facets of the dispute and to also look at the different facets of the settlement and ensure that it is something that is holistic and that really answers the future requirements of the parties also. So that is where I think mediation plays a very significant role. Now, one more advantage of mediation, and one thing that I think we need to discuss when we are talking about establishing a tribunal, is the role of technology. Because technology is already playing a very significant role, and it's going to play a much bigger role in dispute resolution. And one of the advantages of mediation is it's very technology friendly. because there's not much of formality involved. There's not much of documents that you look into. There's no question of examination of witnesses. So the only thing that you need to take care of is the confidentiality part of it, to ensure that there is no breach of confidentiality. And technology, the use of technology, one of the advantages is that it is space agnostic and time agnostic. So as Mr. Dinal was pointing out just now, in the Bangladesh arbitration that took place, you got onto a call with somebody who was sitting in UK and somebody who was sitting somewhere else, New Zealand, yes, and different time zones. So now these are all the advantages where I think, see, the focus now globally is on the MED-ARB, the mediation arbitration policy, where you first go for mediation, try to get the dispute resolved through mediation, and if that fails, then you go for arbitration. It makes a lot of sense, because if a dispute can get settled through mediation, because I'll just give you a small example of what Italy did. Italy brought about mandatory mediation. But for some technical reasons, the courts in Italy struck down that. So they came up with an opt-out model. So basically what happens is, it is mandatory for the parties to attend at least one session of mediation. And what they found out was that almost 70 to 80% of the disputes that the parties went for one session of mediation, they continued with the mediation and they settled in the mediation. So in that way, the importance of that, see, basically people don't know what is mediation. We have a very rough idea of what is mediation. We think, okay, you just make two people sit and talk to each other and resolve it. Sorry, when you undergo mediation training, you realize what a nuanced and what a complex process it is. Because a mediator undergoes quite an intensive training in how to handle emotions of people, how to navigate all those obstacles that come up in the negotiation, how to break the impasse that may come up in the negotiation process. So it's a very complex process. It's a very nuanced process. So when you have that, when you do that, invariably what happens is, if in the hands of a skilled mediator, there are very few disputes that cannot get resolved. So you use that first, and if that fails, because there are different possibilities here. See, now supposing there are 6 issues between the parties in dispute. 3 issues may get resolved in mediation, and 3 intractable issues may go for adjudication through arbitration or whatever other adjudicatory process. So there are different ways that it can be done. But what it does is, it does simplify the whole thing. And what happens is, when the parties go through the process of mediation, even if they don't settle, they get a different perspective of the dispute. Okay, because their perceptions get challenged in the mediation process, and they're able to look at the dispute from different perspectives. And that helps them to, it gives them a different insight. And they're able to find resolutions that would really work for them, right? So that is where I feel that mediation can play a very significant role.
Just playing the devil's advocate, in case, as you said, if the disputes are not being able to resolve through mediation, and despite the fact that there would be perspective being drawn out from the entire process, do you think that the reluctance towards mediation currently is because the process could just be elongated? Because if the dispute is not resolved through mediation, then it goes to arbitration or any other forms of dispute resolution, and then the entire process just gets elongated. What would you like to say about that?
See, the simple answer would be that if I have a problem, a health issue, the question is, would I first try to cure myself through medication, or would I directly go for surgery? Now, just because the medication is going to take a little more extra time, am I going to bypass that medication thing and try to get healed through the medication, or am I going to go directly for a surgery? Now, does the surgery really solve the problem? Now, these are the questions that you need to ask yourself, right? So, why don't we try that? I mean, it may take some time, it may cost a little more perhaps, but there is a potential for you to find a solution that would be really, long-lasting, sustainable, relationships will be preserved, right? There are so many possibilities out of that. So that is a simple question that we need to ask ourselves, that are we really going to bypass it simply because it means we are going to be spending some more time on it? Because it's a very simple, I mean, it's a no-brainer there, that if I have a disease, I would first try to cure it through medication, right? So if I have a dispute, I would try to resolve it through mediation. And if that fails, then I would go for whatever the drastic processes that are there, like a surgery. So arbitration and litigation are nothing but surgery, right?
Thank you so much. With this, we conclude our panel discussion, and I'm extremely grateful to have all the panelists on the stage. We would like you all to give a huge round of applause to all the panelists over here. Thank you so much, gentlemen, for being here, taking out time from playing cricket and being here. I would like to now have a question answer round. The audience, if anyone would have any questions for our panelists, we are happy to entertain them. And we would encourage you all to have your questions addressed, because we do not get time to have all the esteemed panelists to be under one roof at all times. So please, over to you, audience. Any questions? Yeah. You could introduce yourself and then say to whom is it directed to.
Thank you. I was enjoying truly the discussion related to setting up a tribunal regionally to resolve the dispute related to sports. I was burning with a few questions, but one question has been already clarified by Mr. Mudassir, that, whether it needs to be agreed by the, inter-institutions or inter-countries. So that part is there, but still I'm having a question in my mind that whether it will conflict with the jurisdiction of the case, because what I'm trying to say actually that the jurisdiction of the case is quite open and wide, and anyone can go there. So if we set up a tribunal here, then which need to be chosen, whether I will come here, whether I'll go there. So that could be one of the things actually. This is one thing. Another thing is that, whether how far it will be binding upon them. So that need to be, thought before we, start something. So that was the question. But I have one suggestion to the, authority or to the organizers, that you see, the lawyers are working for the justice seeker to ensure their justice in a quick and affordable way. So, and especially for the poor and vulnerable. So is there any possibility in coming Lawyers World Cup that we will have more interaction with the lawyers so that they can discuss about the, how things are happening over there relating to the, case backlog or prison overcrowding and stuff like that. So those are really important because we are having the same challenges for the justice system. So is there any opportunity for future, so we can have more interaction on those issues as well? Thank you.
I'll just try and address the question in relation to the jurisdiction. The whole concept of the jurisdiction stems from the fact that it's consent-based. So it's a consensus amongst the parties based that is reflected in the contracts. So when there is a contract between a franchisee and a franchisor, the arbitration clause would dictate exactly how the process would be done. Similarly, when there is a player's contract between the board and the player, then and if there are codes, anti-corruption, doping, that code dictates exactly what process is to be followed. So, for example, in an anti-corruption process, maybe there is a disciplinary panel formed by the board. Amongst the disciplinary panel, a tribunal is constituted. Tribunal gives a verdict. That verdict is challenged in an appellate jurisdiction before a chairman of the panel. And when that chairman passes a judgment, that if the court says that it has to go to CAS, it has to go to CAS, because that's what the parties agreed to. If the setting up a tribunal is acknowledged, recognized, and effective, then by all means, these boards, these stakeholders, that's why I've been saying from the very outset that the stakeholders needs to come in, the stakeholders have to agree, and no better way to get all the stakeholders involved than to get the government from all this Southeast region to agree to something. So when that happens, the code will itself reflect that the final appellate forum would not be CAS, it could be the tribunal in Sri Lanka. So since it's all consent-based and arbitration clause-based, so it could be done, and there wouldn't be any conflict if those codes are amended accordingly. Thank you.
Anyone would like to add anything?
Any other questions? Yeah. So could you be a bit loud, please? Thank you, sir. Would anyone want to add anything to the suggestions? Yeah.
I think it's a very thank you very much for that very practical and suggestion, which is a simple way forward. Let's start with the cricket and with the local boards. Once cricket is tied up to this center, then we can move to things like soccer, which again played a great deal in this region. Obviously, we can't get the F1 guys to come here, but they'll be uncomfortable, etc. And it's not a sport that's in this region. But certainly soccer and cricket are two sports we can really focus on.
Shukran.
Thank you. Any other questions? Yeah.
Good evening, esteemed panel. My name is Chandrika Manavendra. So in terms of developing an environment that is hospitable for arbitration and mediation, in terms of the auxiliary services available, representation and all of that, what soft skills and competencies would you encourage for aspiring professionals to acquire to be effective in this field?
Who would like to take that? Could you, everyone has heard the question? Could you just repeat your question, please?
So as an aspiring legal professional, to be effective in this industry, to provide the services to this aspiring hub of mediation and arbitration, what competencies, soft skills should we acquire to be effective, to create that environment and intention to have an effective arbitration model in this country?
See, there are some very fundamental skills that you need basically across whichever profession you might be. Now, I call them as 3 Ps: people skills, process skills, and problem solving skills. So these are the skills that any professional needs to develop, no matter which profession you are. The ability to handle people, to be able to deal with them, to be able to, deal with their feelings and emotions, to be able to deal with difficult situations that you may face, supposing you're working with a team. I mean, I'm sure even a cricket captain would need that kind of skill to be able to handle his teammates, right? So that is one. Number 2 is process skill. Like for any system to work properly, you need to have the proper processes in place. And you need to be skilled in using that process as effectively as you can. And the third skill that you need is problem solving skills, where you need to have the ability to think out of the box, to come up with solutions that would really be able to, resolve the problem that is at hand. And instead of thinking in the box, you have to think out of the box. And for that, I think we Asians are famous. We in India, we call it as jugaad. So we are very good in that, right? We are very good problem solvers. But the only question is that problem really getting solved, or is it temporarily getting patched up is the question. So you need that skill also to be able to solve the problem, to be thinking out of the box, to be able to bring everybody together on a platform where they can agree that, okay, this is the process we are going to follow and these are the solutions that we are going to be working at. So just to sum it up, people skills, process skills, and problem solving skills. These are soft skills that not just as a professional, but you need as a person, as a human being, you need these skills. So that same thing would apply across the board to even lawyers, to mediators, to arbitrators, to everyone, including the tribunal that would be formed. That is my point of view. If anybody would like to add more to that, I mean, I'm sure there's a lot more to add.
Anyone? Thank you, Jawad sir. I think you covered everything. I hope your question has been answered. We will be taking the last two questions. So if anyone has, yes, please.
Good evening, panelists. I'm Darusha Fernando. So one of the most important things that we talk about cricket or any sport is that the separation of politics and arbitration or politics or the judiciary, right? But in considering the most of the jurisdiction, whether in Sri Lanka, Pakistan, or India, we see in Pakistan the board is appointed by the executive. We see in Sri Lanka there can be executive ad hoc committees put in again. So in arbitration, as the panelists said, the jurisdiction is based on consensus. So what would you advise in these situations where the executive can ad hocly pick and choose on what to implement or what not to implement? And if so, how can the region can come to a consensus on jurisdiction when we have these national laws still in place, even though we implement new laws?
So, if you don't mind repeating the last part of your question again, that it is consensus-based, but your interplay with the national law, you were saying something about that.
Yes. So, for example, within the Sri Lankan jurisdiction and within the Sri Lankan law, there are provisions where the sports minister can intervene in certain instances, right? Sure. So, but in arbitration, we believe that in the regional, there should be regional consensus when it comes to establishing jurisdiction. Yeah. But in a situation where a decision has been given and we see executive ad hoc placement, in that kind of situation, what would be the situation
So you are asking where does this whole arbitration comes in when you're coming from the angle of interference of the executive in the administration of something, right?
Yes, sir.
That's not within the purview of the arbitration.
For example, if it is India and Bangladesh, there's a tribunal.
Yes.
Those two countries will have their own laws too.
Absolutely. So each of the jurisdiction will have their own set of national laws, and that would obviously be applicable. But from what I understood from you were saying what will happen if the executive steps in. Executive interference in terms of administration is something different. And it's got nothing to do with the arbitration process. Because arbitration, the parties there is a dispute in question in respect of corruption, doping, commercial merchandising, endorsement, whatever. So in those cases, those interference, literally there is no statute that gives us direct power to interfere. It's entirely contractual based. So the arbitration tribunal would be adjudicating based on the facts and the contract, right? So once again, the jurisdiction would stem in from the consensus as well, from the parties.
Just to add to that, under Section 32 of our sports law, it stands today, the minister can't willy-nilly charge in like that. He's got to call upon the offending body to regularize it. Then if they do not regularize it, then he has powers to make certain interim arrangements. So as far as an arbitration tribunal is concerned, if there is a dispute between, say, a player and the governing body, then that matter is referred to by the player or the governing body per se. So that dispute between the minister interfering has nothing to do with the arbitral body hearing a dispute. Arbitral body will hear only a dispute. They will not hear a dispute between the minister and the governing body. That is resolved elsewhere in the appellate courts. Am I clear to you?
Yes, sir. Thank you very much for the clarification.
Thank you. We'll be taking the last question. If anyone has.
Yeah. Hello everyone, I'm Ravi Varman. So, as the panelist mentioned, compared to the cost of arbitration in the Switzerland, so when we establish a international tribunal in Sri Lanka, the cost may drop down. But still my question is concerned about the athletes at the national level who are even finding it hard to survive in the sports except cricket. In the sports where we are developing, they would find it unaffordable to spend for international arbitration. Is there would be any other solutions for that?
Perhaps mediation might be an answer for that. Because it's much more affordable than arbitration. See, one thing you need to keep in mind is that there is a fundamental difference between mediation, that is, mediation is a collaborative process, right? And adjudication is a competitive process. So in mediation, the entire control is in your hands because you are the ultimate person who's going to take the decision, right? So it's not in anybody else's hands. A mediator cannot tell you or cannot adjudicate the dispute. So the mediator basically only facilitates. So it's a much cheaper process comparatively. When you compare it, it's more, in terms of time, in terms of cost, it is much less expensive than any adjudicatory process. Because in an adjudicatory process, basically you need to depend on somebody, you need to pay a lawyer to appear for you, because you may not be well aware of the statutes, the laws, the rules and regulations. In mediation, because it's a consensual, even arbitration is consensual, but that is adjudicatory. Mediation is entirely in your control, and you are the main person who's going to be a part of the whole decision-making process. So it's in your hands. So that might be an alternative that you can consider. But that may not answer your question fully because you are talking about, where do you go for meeting the cost? Because athletes, except the cricketers, all other athletes are not really. We have seen pictures of people who have won medals in Asian Games washing dishes in India. We have seen those cases also. It's pathetic. I mean, if a dispute confronts them, what do they do? Because see, again, mediation involves two people. Both sides have to agree. So therefore, sometimes adjudication may be required. So where do they go for the money for that? I think that's something the local administration of each country will have to look into that and provide legal aid to those athletes who cannot really afford. So that would be the only way out. Other than that, I don't think that it will be fair to expect the athlete to spend money and to fight their case and to pursue it to its logical conclusion. So I think some kind of a legal aid may be required. So that would have to come from the administration, from the local, from whichever country they come from. Or maybe the sports body can fund that. The federation or the club or the association can perhaps support them in agitating their rights.
Thank you, sir. Hope your query has been addressed. With this, we conclude the panel discussion. And once again, I would like to thank all the panelists over here for taking out your time amidst the World Cup matches and the busy schedules. Please give them a huge round of applause, guys. And also, I would like to thank the audience. We were limited in number, but we were very energetic. So please clap for yourselves as well. Thank you so much.
Yeah, and thank you, Sadia, for being active throughout the course of the event. And oh, and she's not well, and still she had the energy. She reserved her energy for this proceedings. And yes, a huge round of applause for her as well. Over to you. Thank you.
Thank you to our wonderful panelists for their unique and inspiring perspectives, and of course to our accomplished moderator for helping us shape such an amazingly fruitful discussion. For anyone who would want to revisit this discussion, you can watch the replay of the live stream on the Sri Lanka Lawyers Cricket Club YouTube channel. Now, ladies and gentlemen, as we approach the conclusion of today's conference, it's time to express our heartfelt gratitude to those who have made this event possible. For every successful event is a collaborative effort, and we are fortunate to have had the support and dedication of some remarkable individuals. To deliver the vote of thanks, please warmly welcome on stage Mr. Teja Silva, attorney at law and former president of Sri Lanka Lawyers Cricket Club, to deliver the vote of thanks.
Good evening, ladies and gentlemen. Distinguished speakers and members of the panel, I am aware that you have been listening to a lot of speeches, so I'll make it very short. But I'll be remiss in my duties as the chairman of the organizing committee of this 8th Lawyers Cricket World Cup if I didn't say a few words thanking those who made these events a reality. So, on behalf of Sri Lanka Lawyers Cricket Club and the Cricket Association of Advocates of India, the joint hosts of this 8th Lawyers Cricket World Cup, of which this seminar and the panel discussion was an integral part, let me express our sincere gratitude to the very distinguished speakers and panelists taking part in today's event. I am personally aware that a lot of hard work was put in by the distinguished speakers and the panelists during the last few weeks, and especially during the last few days, where they spent a lot of their time, voluntarily I must add, to make this event a success. In the same breath, I would like to thank the conference chair, Dr. Malika Gunasekara. When we agreed to host this Lawyers Cricket World Cup, I was quite confident that we will have no problem in organizing the seminar, which has always been an integral part of the Lawyers Cricket World Cup, because I knew I could rely on my good friend, Dr. Malika Gunasekara, like we did in 2007 when we last successfully hosted the World Cup, to organize the seminar. I simply asked him that you have to take the lead and organize this seminar, and today it was a reality. I would also like to thank all of you who are present here, because without you, this seminar would have been meaningless. Unfortunately, the rain played spoil sport. Today was supposed to be a rest day from the cricket, but 2 matches had to be rescheduled for today. That would mean 4 teams. We have 5 countries here. 4 of those countries were involved in matches today, so that affected the attendance a little. So on behalf of the organizers, my apologies to the distinguished panel for the lack of the numbers in the audience. Also, let me just take 2 minutes. As the chairman of the organizing committee of the Lawyers Cricket World Cup, I would also like to take this opportunity to thank the members of the International Committee of the Lawyers Cricket, firstly for those who are being here, and also those who unfortunately could not be with us this time. Firstly, for changing the venue for the 8th Lawyers Cricket World Cup, accommodating Sri Lanka's request, because we were simply not in a position to travel far with the economic conditions in Sri Lanka prevailed 2 years back. And a big thank you to the West Indies for graciously agreeing to give up their chance of hosting the World Cup. And thank you to India for agreeing to host the 8th World Cup so that we could just hop across the canal and go there. But unfortunately, due to some events which were beyond the control of Indian lawyers, the World Cup had to be brought to Sri Lanka, and it is now jointly hosted by Sri Lanka and India. And so I would like to thank our sponsors, AVR Group, and also Sri Lanka National Arbitration Center for the support extended to us. So once again, ladies and gentlemen, thank you very much for your valuable time. This event is followed by a small reception outside. I hope to see you all there. Thank you.
Thank you, sir. And that brings us to the end of today's conference, at the heart of which was the message that the field of sports law is not just a legal domain, but a diverse and vibrant arena where rules, ethics, and the spirit of competition converge. I'd like to extend my sincere thanks to our distinguished guests, speakers, all participants, and the several viewers who joined us online through the live stream for being a part of this insightful journey today. It has been a pleasure being your host. Thank you and have a wonderful evening. And if I could request all the speakers and panelists to please come to the front for a picture. Thank you.